me here. Good morning. In the High Court of Northern Ireland last year, Mr. Justice Schofield described a gender recognition certificate as conferring, and I quote, a significant and formal change in a person's status with potentially far-reaching consequences for them and for others, including the state. These far-reaching consequences flow mainly from two sections of the Act, not mentioned by name in the committee's sessions so far. Section 9 sets out the effect of a GRC. It provides that a person's acquired gender becomes, for all purposes in law, except in a few defined circumstances, their sex. Section 22 puts in place stringent privacy protections. It creates criminal offences for disclosing any information about a person's past identity or current status as a GRC holder, if that knowledge was gained in an official capacity, again with limited exceptions. A key question for the committee is how these two sections interact with the Equality Act. We and others sent in a joint briefing to you about this following comments made in the first public session. We highlighted that the legal position here is unsettled, and that several influential organisations believe a GRC does change somebody's sex under the Equality Act, with implications for how organisations can practically provide single-sex services in line with the law. I'll mention one example from our briefing. In 2017, a Scottish Government email recorded a member of the Equality Network staff telling civil servants that the use of sex and gender interchangeably in Section 9 was, quote, intentional and should be retained. And the wording's purpose was to make sure that GRC holders would not be prevented from accessing services based on their acquired gender. In a further internal note, a civil servant then recorded that the government was keeping this wording in Section 9, quote, for policy reasons. It's clear, therefore, that in developing this bill, both the Scottish Government and the Equality Network have viewed GRCs as much more than just a piece of paper. That was in 2017. Much more recently, the Scottish Government has again demonstrated its belief that a GRC changes someone's sex for the purpose of the Equality Act, and Susan will say more about that. In public, Government and its supporters may maintain that GRA reform, as proposed here, will not affect the operation of the Equality Act, but the committee needs to dig much deeper into that. We are, of course, at a disadvantage here because the minutes of the committee's private briefing with civil servants in March do not record what they said to you about this. But think of it this way. If a GRC is a sort of key and you're going to hand out lots more copies to a more diverse group, the first job of legislators is to be really clear about what that key could unlock. Meanwhile, there's no dispute that all GRC holders, and also in future all those who claim they've already obtained gender recognition overseas, will benefit from Section 22. The committee therefore needs to consider what it means to extend such strong protection to a much larger, more diverse group, including young people still in school, based purely on self-declaration. 3 years ago, the Scottish Government said it would tighten Section 22, but instead the bill extends its reach. Our written evidence to you discusses these points and others, including cross-border effects, the far-reaching provisions for overseas gender recognition, and, very importantly, how the government has handled its assessment of potential impacts on women. Coming back to Mr. Justice Schofield, he said a GRC is a, quote, major change in the status of the individual in the eyes of the law. Understanding fully the nature of that change, and anything about it that's uncertain, should be the committee's starting point. Convener, speaking from 20 years in policy making, most of that in what's now the Scottish Government, and years since researching public policy, I am serious when I say that the process leading to the introduction of this bill has been exceptionally poor and a recipe for bad law, and I hope the committee will now correct rather than repeat these mistakes. Thank you.
Thank you, Lucy. And can I hear from Susan Smith, please?
Thank you, Convener Committee. Despite a legal fiction enacted 18 years ago, out with science fiction, people cannot change biological sex. The Scottish Government claim to understand the difference between sex and gender, but have used legislation and policy to erase sex or conflate it with gender. For Women Scotland recently won a case in the highest court in Scotland over the definition of women in the Gender Representation on Public Boards Act. In the ruling, the judges said that provisions in favour of women, by definition, exclude those who are biologically male. They determined the definition in the statutory guidance based on self-ID should be struck out. However, the Scottish Government's proposed correction is to define women on the basis of Section 212 of the Equality Act, plus those in possession of a GRC who have changed their legal sex to female. In short, while ministers and civil servants may swear blind to this committee that a GRC does not change a person's sex under the Equality Act, this Act suggests they don't really believe it. The GRC, as Lucy said, conflates sex and gender. Meanwhile, confusion and coordinated campaigns have undermined how single-sex spaces operate, and this is reflected in the submissions you've received, in policy documents and in workplace guidance. We think many have the law hopelessly tangled, but while the Scottish Government are not prepared to defend women's rights, reform will make things immeasurably worse. Another bad law will, like others before, end in the courts. By doing away with all eligibility criteria, this bill effectively opens up the process to everyone. There is a frankly naive expectation that no one will act dishonestly and that solemn declarations are the most binding of magic. While much has been made of the vulnerability of trans-identified people, there has been little recognition that the people who will suffer under the loss of single-sex spaces, which providers will find increasingly difficult to operate, are genuinely some of the most marginalised and abused in Scotland today. While the committee took private evidence from selected individuals, some of which related to experience rather than the application of law, I recently listened to heartrending accounts of women who have self-excluded from women's services and the evidence of how trauma has ripped their lives apart. These women have then been demonised, sometimes by the very organisations who were supposed to protect them and betrayed by those who should have supported them. If lived experience matters to the committee, theirs should too. Frontline workers and board members have told us that the women at the top of the funded organisations did not consult independent centres before declaring for self-ID. Many try to maintain a de facto single-sex policy in spite of this. We are concerned that the committee set the schedule for witnesses before studying the evidence and that there has been gaps in previous panels. For example, no mention of the CAS review or detransition on the panel on young people. I am sure the committee will reference international best practice, and we would like to understand what you think this means. We know previous witnesses referred to the Joggiakarta Principles, a document that signally fails to consider women, in submissions. Human rights lawyer Professor Robert Wintermute was a co-signatory to these principles and has written to this committee offering to give evidence, but has not been called. If you really wish to understand, this seems a shocking omission. There has been much talk of misinformation and abuse. We would agree, but it does not come from the people sitting in front of you now. Sadly, some misdirection has come from government-funded organisations who enjoy privileged access to ministers. Abuse of our organisations has come from people working in Parliament, from members of cross-party groups, and was even published last week on the Scottish Parliament website. Disgracefully, one of the organisations on the next panel put out a hugely inappropriate comment about this session in their newsletter last week. Meanwhile, ordinary women, shut out from the process, have to protest outside Parliament in order to be noticed. This committee has much work to do, and biased or partial evidence collection will not make a febrile situation better. Women still suffer disproportionately from domestic violence. We are overlooked in medical trials. Our health conditions taken less seriously. We are paid less and take on more caring responsibility. Our sex is a factor in this, not our clothing preference or our pronouns. By erasing and confusing sex in law and policy, the Scottish Government will not resolve any of these equalities, but they will make it considerably harder to monitor injustice and to fight for change.
Thank you. We now move on to Dr. Kate Coleman, please.
Thank you, Convener. Thank you, Committee. Keep Prisons Single-Sex campaigns for the sex-based rights of women in prison to single-sex accommodation and same-sex searching. We also campaign for data throughout the criminal justice system to be collected by sex registered at birth. We work closely with current and former female offenders throughout the UK, and this informs our work. We're opposed to this bill and have concerns regarding many of its proposals. My focus today is the likely impact of the bill on women in prison and on data collection. This bill makes bold substantive changes to the operation of the Gender Recognition Act, the intended function that a GRC should serve, and the criteria which applicants must fulfil. The impact will be seen across the UK, beyond the borders of Scotland. This is not merely a matter of administration. Earlier this year, Lady Dorian observed that the protected characteristics in the Equality Act operate in parallel, and that the protected characteristic gender reassignment as a single category with no subdivision according to sex or to acquired gender is distinct from the protected characteristic of sex. She also affirmed the importance of separate legal protection for biological women under the Equality Act. However, the direction of movement for prisons policy is to treat a transgender prisoner with a GRC differently to a transgender prisoner without. That is to say, as a prisoner of the sex corresponding to their acquired gender. This is certainly the position of the MOJ. The Scottish Prison Service gender identity and gender reassignment policy is currently under review and may well be revised to also give priority status, as it were, to GRC holders. Policy decisions that refuse to allocate and manage GRC holders on the basis of their acquired gender may be subject to challenge, including in the courts. Certainly we've seen that south of the border in the English courts. A system of self-ID removes any variable differentiating trans women with a GRC from males, aside from having completed a legal process. This is particularly relevant for prison allocation and management. We work with partner organisations across a number of jurisdictions, including Ireland, the USA and Canada. Wherever allocation is on the basis of self-ID, it is frankly disastrous for women in prison. When prison services privilege GRC status, the possibility of case-by-case flexibility in the management of decisions that can be made for prisoners is dramatically reduced. Here, I note that the Gender Recognition Panel already conducts no risk assessment when considering an application, nor is there any requirement for medical treatment or surgical reassignment. This past weekend's media reports of the management of a prisoner with intact male genitalia who was able to have sex with a female prisoner at HMP Bronzefield in the female estate is one such example. Sex registered at birth is fundamental to understanding offending and to service provision within the criminal justice system. The importance of sex registered at birth as an explanatory variable and the difference in rates of offending for males and females means that the allocation of even 1 or 2 cases of male offending to the female subgroup on the basis of the suspect's acquired gender can have a significant impact on the data. Here, I note that there's no evidence at all that the rate of offending for trans women conforms to the rate of offending for females. Rather, the evidence indicates that the male rates of offending persist. This bill will have a substantive cross-border effect on policy and practice, and there are urgent questions to be asked about the status of confirmatory GRCs throughout the UK and the limits of automatic recognition of overseas GRCs. Consideration must also be given to the legal implications of creating what will be a 2-tier system in prisons in England and Wales. Prisoners who are Scottish-born and who are housed in the prison estate in England and Wales will be able to obtain a GRC with relative ease by meeting a set of criteria set at a considerably reduced threshold compared to those born in other regions of the UK. The latter will have to complete a more lengthy, involved and arduous process in order to obtain a GRC and to be managed as a prisoner of the sex corresponding to their acquired gender. This arguably changes the operation of the Ministry of Justice Prisons policy, introducing differential treatment on the basis of place of birth. The possibility of legal challenges by non-Scottish-born prisoners must be considered. We do not agree that in respect of data collection or service provision, sex registered at birth should be overwritten by legal gender, gender reassignment, or by self-declared gender identity. These are questions of fundamental and far-reaching importance. We cannot shy away from them, and using the language required to make clear the enduring importance of sex in these areas for fear of accusations of transphobia. I welcome the opportunity to answer questions and to discuss this further. Thank you.
Thank you very much. Can I hear from Malcolm Clark, please?
Thank you, Convener, and thank you, Committee. Many people are surprised when they hear that a group that represents lesbians, gays and bisexuals is opposed to this legislation. That's because they've been told that laws that enshrine gender identity are just the latest front line in the battle for gay rights. The tragedy is that nothing could be further from the truth. This bill sends the message that the biological sex we are matters less than the gender identity that we feel. But lesbians and gays are defined by and legally protected as people who are same-sex attracted. If you replace the fixed, definable reality of sex with the indefinable, fluid, vague concept of gender identity, the rights that we fought for decades for are erased. If sex doesn't matter, gays don't matter. This isn't a philosophical debate. Leading trans activists already argue that the whole idea of homosexuality no longer makes any sense in a world that believes in a gender spectrum. We're here because we beg to differ. The practical everyday effect of this erasure of biology is to tell gay men they're attracted to people with female bodies as well as male bodies. On lesbian dating sites, women who insist they don't want to be contacted by trans women, i.e. people with male bodies, are ejected from the site. It's been estimated that 40% of people on some lesbian dating sites are males who say they are women. This bill amplifies that pressure, that bullying, that homophobic denial of the reality of gay people's lives. It's bad enough for adult lesbians and gays. Imagine what it's like for a teenager coming to terms with their sexuality. Imagine what it's like to be told as a young lesbian that you are equally attracted to women with male bodies as female bodies. Or a gay boy being told that some gay men have vaginas and he'll be attracted equally to female bodies as male bodies. That's what's being taught in Scottish schools. No wonder there are soaring numbers of children who are so confused and troubled they're being referred to gender identity clinics with gender dysphoria. A 4,400% increase in 10 years among girls in particular. The sad thing is, we know the majority of kids with dysphoria eventually grow out of it. We also know the vast majority, if left alone, will grow up to be happy young lesbians, gays or bisexuals. That's why we have a particular concern about lowering the age at which someone can get a GRC to 16. If the state steps in to validate the confused feelings of a 16-year-old girl who thinks she's a boy, this risks crystallising an identity that's just temporary. It also makes it harder for her to revert to feeling like a girl now that she's been told by the state she really is a boy. More than 50 females under 18 were approved for double mastectomies in Scotland in the last decade. If you give girls aged 16 certificates saying they are boys, how many more teenage mastectomies will be approved? The lowering of age, combined with the removal of any medical oversight, means we will now be taking away the chance for young people to be questioned by doctors about their decision and to have their gender dysphoria explored. Gender identity was a concept popularised by the discredited psychologist John Money in the late 1950s. He provided no proof, and as of yet, despite over 5 decades of research, no convincing scientific evidence has been produced to support this idea. Self-ID, in this bill, is the ultimate validation and normalisation of the notion of gender identity. Yet it was only 7 years ago that Stonewall and other LGBTQ+ organisations began to press for this change and for self-ID. This is surely an unseemly rush to legislate, not least since it overturns the common sense of millennia that there are two sexes, male and female, something that's hardwired into human beings as our shared, simplest understanding of our human nature. What's worse is that this bill isn't the end of the gender identity lobby's campaign. They will need more issues to raise funds for in the future, more demands to make a fuss about in order to justify their existence. So I would just say to the committee, beware. The insertion of self-identification into our laws is just the beginning. It will then be used to trigger a whole new series of ever stranger demands that will chip away at gay rights, the interests of women, children's mental health, and the public's tolerance. Yet, here we are, preparing to enshrine this contested, controversial, unproven notion into the laws of Scotland, the land of the Enlightenment. Thank you.
Thank you, Malcolm. So we'll now move to questions, starting with Maggie Chapman, please.